Okay, I think we're going to go ahead and get started. Thank you for joining us this morning. This is the National Register State Rules Proposed Rule Informational Meeting. Um, my name is Katie Guthier. I am the Rules Coordinator for this project. I'm the Government Relations and Policy Unit. And with me today is Ian Johnson. Ian, do you want to introduce yourself? And you're on mute.
Yes, my name is Ian Johnson, and I am the Associate Deputy State Historic Preservation Officer.
And we have Chris Havel. Chris, do you want to introduce yourself?
Yeah, good morning. Thanks for being here. I'm Chris Havel with the Director's Office, the Oregon Parks and Recreation Department.
Great, thank you. So we just wanted to give you a little bit of background about how the process is going to work today. And if you have any questions, you are all muted, but if you need to ask any questions, feel free to raise your hand and then we'll be able to see it and answer those questions. We're going to do some welcome and introductions. Ian's going to do a background and explain the proposed rules. And then I will talk about the next steps for rulemaking. And then we'll go through any of your questions and answer questions. For answering questions, you'll raise your hands and we can go through that process. And then after that, we will end the informational portion of our meeting and move into the public comment portion of this meeting. Anyone is welcome to leave after the informational portion. If you wish to stay and provide public comment or listen to the public comment, you're welcome to stay and listen. And at that point, it will become an official public hearing where people can provide oral comment, and I'll go through that process when we get to that point and have a statement kicking off the official public comment portion of the meeting. So Ian, do you want to get started with an explanation of the proposed rules?
Sure, thank you. So good morning to all of you, and thank you for joining us this morning to discuss the proposed draft rule for the administration of the Federal National Register of Historic Places program in Oregon. For this presentation, I'm going to briefly describe what the National Register is, provide some background on why the agency is revising the rule, and highlight the important sections. This particular session is aimed more to speak to the interests of local governments, so I will spend a little more time talking about the provisions that are more reflective of their interests. It's important to point out as we talk about this rule that this draft rule addresses only the process of listing properties in the National Register. It does not include provisions for the regulation or protection of properties once they are listed, or talk about the benefits or restrictions of listing. The draft rule also does not apply for properties within the boundaries of the reservations of Oregon's 9 recognized tribes, or so that's important to point out. So the presentation will take about 15 minutes, and then there'll be a Q&A period following. So the National Register of Historic Places is the nation's official list of buildings, districts, structures, sites, and objects important to local, state, or national history. The program is run by the National Park Service and administered locally by the Oregon State Historic Preservation Office. That's the SHPO, which is part of Oregon State Parks and Recreation Department. The listing process begins when a nomination is submitted to our office and is deemed complete. The local government then has an opportunity to comment on the property, and that's the local government where the property is located. That recommendation goes to our review board, which is called the State Advisory Committee on Historic Preservation. They look at the recommendation and make their own, and they make that recommendation to my supervisor, who's the Deputy State Historic Preservation Officer, who looks at the record and then makes a recommendation to the National Park Service. It is the National Park Service that makes the final determination whether a property is or is not listed in the National Register. When a property is listed in the National Register, it's first and foremost recognized as important to the history of the nation, state, or community. It will be considered in the planning of federal or federally assisted projects. So for instance, if you're putting in a federally funded road, like a freeway, those properties that are listed in the National Register are considered as part of that process to make sure that the federal action minimizes impact on them. Properties listed in the National Register are eligible for federal and state tax benefits and grants when those are available. And properties listed in the National Register may get leniency meeting certain building code requirements in Oregon, depending on the community. And you'd have to contact your local building inspector or planning department to determine what that may or may not be. If an owner of a National Register property chooses, and it's important to say they choose to take advantage of the federal and state tax benefits and grant programs, they must meet federal preservation standards in order to accept those funds. Under the Department of Land Conservation and Development's Goal 5 rule, and for those of you who like to check references, that's OAR 660-023-0200. Oregon state law requires local governments to review proposals at a public meeting to demolish or relocate properties listed in the National Register. The local government must consider a number of factors in their decision, but these are not decision criteria. I'll read briefly the factors, which include condition, historic integrity, age, historic significance, value to the community, economic consequences, design or construction rarity, and consistency with and consideration of other policy objectives in the acknowledged comprehensive plan. The local government may choose to allow or deny demolition or relocation or modify the proposal. The local government also has the authority to establish additional protections for properties listed in the National Register through a separate local public process. The National Register rule is administered by the SHPO, is separate from the Department of Land Conservation and Development's rule. However, we recommend that local governments be familiar with both, and certainly property owners as well. Hey, Katie, can I get the next slide? So a little bit of background on the rule. In the last 5 years, several high-profile controversial efforts to nominate properties have come up with the National Register program. These have exposed problems with how our office administers the program. Specifically, what we've observed is gaps or conflicts between required federal laws and state processes and procedures, unclear or unaddressed administrative processes, such as how tribes and local governments participate in the nomination process, how public notice and participation are conducted, hearing procedures, and the process for keeping culturally sensitive information confidential. Also, there was a very clear need to better define how to count property owners and objections in order to establish owner consent as required by federal regulation. The purpose of the new rule is to implement the Federal National Register of Historic Places program in Oregon so that the process encourages participation, is fair, clear, and transparent, and federal law is consistently applied. Then what we're calling the National Register rule is actually several rules, and run briefly through those sections. It begins with a statement referencing the applicable federal regulations and adopting them. Then the next rule is definitions, followed by the organization and duties of the Citizen Review Board that reviews nominations. Again, that's the State Advisory Committee on Historic Preservation. The next is staff processes, describes how staff handles and processes and reviews nominations and how we support the review board. The next is how the SACHP holds their public meetings to consider the nominations and make their recommendations as part of the process. And there's a final section that lists the documents incorporated by reference and when the rule becomes effective. Next slide, please. The first goal of the rule revision is to encourage participation, and it does this in a few different ways. The rule defines, first of all, the participants. The proponent, who is the person nominating the property, has a definition of owner, local governments, and tribes, and they're included throughout the process. It's important to state that the definition of tribe is limited to one of the 9 federally recognized tribes in Oregon. And the rule, again, also includes provisions on how they can be involved. The rule includes a provision inviting any person to comment on a nomination at any time during the public comment period. And there is a defined public comment period, which opens the day that our office notices that the nomination will be considered by the review board and ends on the day that the National Park Service makes its final decision. The rule allows the SHPO to coordinate with local governments on the format, content, and distribution of the public comment period notice, and allows the SHPO to take additional steps to notify owners as needed. The rule requires public comment opportunity at SACHP meetings, which can be provided orally or in writing, depending on how the individual would like to provide it. There's an opportunity for state agencies and local governments to comment as well. And local governments may also choose to waive their comment opportunity if they choose to. In some cases, they would do that if they were sponsoring a nomination and they wanted to kind of move it through the process. Tribes may choose to participate in a public process or may choose to engage more formally in what's called government-to-government consultation. Oregon's 9 federally recognized tribes are under the U.S. Constitution sovereign nations, and they have an ability to speak to Oregon state government as a peer government. However, that consultation is always part of the public record. Next slide, please. The next goal of the rule is to make the process fair, clear, and transparent, and that begins with accurately counting owners and objections. The new rule includes a new definition of owner. I'll read part of it here. Quote, the owner of fee simple, absolute, or fee simple defeasible estate title to a property as shown in the property tax records or the county where the property is located, including but not limited to trusts, limited liability corporations, and any other legal entity that can hold fee simple, absolute, or fee simple defeasible title to real property within the state of Oregon. That's the end of the quote. Subparts address special considerations such as life estates and sale contracts, and I would encourage folks to read closely through that. Note that this definition means that under federal law and this proposed state rule, a single property may have many owners, including ownership entities such as trusts and corporations, where a single or small group of individuals may be the trustee or chief officer of many of these individual trusts or other ownerships organized situations. There's also a clear process for how the SHPO creates the owner list and the process that owners may object, remove their objection, and or correct the owner list. There's also a process for contesting the SHPO's processes or counting of owners and objections, including there's also provisions for requiring owners to provide evidence that they meet the definition of an owner, and a provision that allows unresolved matters to be taken to a state administrative law judge to make a final ruling. The draft rule describes how nominations move through the process more clearly. It defines substantive revisions or changes that would require a nomination to walk again through the process, either starting all the way at the beginning or perhaps just being reviewed again by the review board. Using the federal criteria, the rule defines the local landmark commission and SACEHP's or review board's decision criteria. The rule defines what actions that the review board can take when reviewing a nomination, recommend with edits, deny, or ask that the nomination come back at a later time for reconsideration, and what circumstances under which the group must see a nomination again. Again, those would be substantive revisions. The rule states that the committee may provide courtesy comments for properties located on federally administered lands, so lands run by U.S. Forest Service or BLM, for instance, or nominations submitted by a tribal government or by a federal agency on behalf of a tribal government. The rule requires the SHPO to provide a copy of the nomination as sent to the National Park Service for review to the same parties that were included in the original notifications. And those parties would include the proponent, the owner, the local government, and etc. The new rule also lays out processes for what happens when a nomination is returned, unlisted in the National Register from the National Park Service for corrections. Previously, it was not clear on either federal law or rule or state law or rule what would happen when a nomination was returned. And so that process is outlined more specifically. In those provisions, the SHPO is required to determine whether to revise and resubmit the nomination or restart or terminate the nomination process, and to clearly communicate its decision to the proponent, owner, and local government before making a decision and taking next steps. It also includes a provision to restart the process if a property is not listed in the National Register within 2 years of its original submission. It's important to point out that this provision does not apply to those nominations submitted before the effective date of the rule, basically all those that are currently in process. There's an opportunity to appeal any decision of the SHPO directly to the National Park Service, which is already provided in federal law and then explicitly stated here. The rule does not limit when comments can be submitted, including objections, because the federal practice is to keep the comment period completely open until the National Park Service makes its final decision. While we acknowledge that last-minute submissions may delay the process, we're confident that the provisions of the rule addressing counting owners and objections and the appeals process will provide a way to move nominations through the process. Next slide, please. We've been talking a lot about how, off and on, about how the rule is lined up with the federal processes, and that's the big third goal of this entire process, is to make sure that our state processes are aligned with federal law and rule. I'm going to highlight just a moment here some things that didn't fit into the earlier parts of the presentation. So of course, all parts of the rule carefully examined ensure consistency with the federal program. The state level nomination procedures are framed within this. As I mentioned before, the federal criteria for evaluating National Register nominations are included in the draft rule at every level of review, initially by staff, then during the public comment period, and review by local government, and review by the review board or that state advisory committee on historic preservation, and finally our office before it's submitted to the National Park Service. The rule does briefly note that all or a portion of a National Register nomination may be held confidential under applicable state and federal laws, but it does not include a specific process for doing so. Instead, it leaves the process to staff to create as an office procedure. The rule also clearly defines the process by which a local jurisdiction may object to a nomination and stop the nomination process. It's important to point out that a local government may only object and stop the process if they participate in the Federal Certified Local Government Program, which is a partnership between the National Park Service, our office, and the local government. In that program, a local government has a landmarks program and a landmarks commission. Generally provides pass-through funds for preservation activities in the community. Under the federal law, a local government may object to and stop a nomination process when the chief elected official, who is the mayor or chair of the County Board of Commissioners, and the Landmarks Commission each separately provide a letter to our office stating that they object to the nomination. Now that objection can be contested by any individual who would submit a written letter to our office saying they objected to that objection, in which case the nomination, according to the rule, would be heard at the next regular meeting of our review board, the State Advisory Committee on Historic Preservation. A certified local government would have the opportunity to object to a nomination every time it was substantively revised. So if there were major changes, it would essentially allow them to object again. So that's the end of my presentation at this point. As I understand it, it goes back to you, Katie, and then you'll go ahead and chat about the process before we take questions.
Yes, great. Thank you, Ian. So we just wanted to give you a little bit of background about what the next, where the process goes from here. The comment period is set currently to close on August 31st. The comments will then be compiled and shared with the Oregon State Parks and Recreation Commission. They're accepted through August 31st at 5 p.m. The staff report will go to the commission with a recommendation on a revisions to the proposed rules. At that point, the commission could vote to adopt the rule changes as proposed. They can make amendments based on comments received, or they can seek additional public comment to the rule changes, or they could choose not to move forward with any proposed rule changes at that time. So that is basically where we'll move moving forward after this. Comments can be submitted on our online using our comment box on our website. They can be sent in writing to our office or via email, and that's our email box. And they are accepted through August 31st at 5 p.m. So at this point, we are open to questions. Ian, do you want to talk about the questions that were submitted beforehand? We'll start with those, and then after that, we'll move into any questions that anybody has.
Sure. So prior to this meeting, we were submitted, 4 questions were submitted by the city of Salem, which I think will probably be relevant to everyone. I'm going to go ahead and read the question and then go ahead and answer it. So 4 question. First has to deal with the definitions in the Rule 736-050-0230. The question is, can you please clarify why the definition of conflict of interest has been removed? This term is utilized in OAR 736-050-0260 and doesn't appear to be defined anywhere else. That is correct. It is not defined anywhere else, and we did remove the definition of conflict of interest, as well as a lengthy discussion off and on throughout the rule about conflicts of interest. And the reason is this is conflict of interest as a term, and the process for identifying it and what public officials need to do is well defined in Chapter 244 of the Oregon Revised Statutes. It's not unusual for that law to be changed from time to time by the legislature, And so instead of including a reference that might become dated over time, or to try and cram in what is actually a pretty hefty body of law, we simply removed it. However, based on that comment, staff will consider if a reference to the state law would be helpful there. Question 2 deals with the SACHP organization and duties. That's Rule 736-050-0240. It's a comment. It is unclear why the requirements for the SACHP meeting quorum are in 736-050-0260 instead of the 0240 section. So this is asking, why is it in one section versus another? It could be in either section, and we'll consider that. The reason why it's in the section it is 0260 it describes more specifically what happens at the meetings. And so the decision was at a meeting, it's where you would determine whether quorum was or was not met, but it could easily go into the earlier piece talking about the organization and duties of the review board of the SACHP, and we'll consider whether it makes sense to include it in one place or the other, or both. That was a good comment. Thank you very much. The National Register Program, staff duties, that in the draft, that's Rule 736-050-0250. The question is, proposed amendments do not require SHPO staff to notify the CLGs of the SACHP action, in parentheses, here's a recommended approval or denial, or the action of the deputy SHPO, in parentheses, should they reverse the recommendation of the SACHP to the National Park Service. Here's the question. Would it be feasible for SHPO staff to notify the CLGs of the SACHP and or SHPO recommendation at this step in the process? So yes, it would be, and we will consider it. The rule already includes a provision to provide a copy of the National Register nomination as it is provided to the National Park Service when we send it forward. We send all those nominations with a cover letter that's basically our recommendation and summarizes the process. So it would not be much of a stretch to just include that with the nomination since we're already preparing those materials. So we'll consider that. Finally, question 4 references SACHP procedures for review and approval of nominations. This is OAR 736-050-0260. The question, can you please clarify how the proposed rule under section 4 that allows, quote, the owners and chief elected official to waive the CLG comment opportunity outlined in OAR 736-050-0250, subsection 10, would work in practice if there's a disagreement between an owner, chief elected official, and an HLC. For example, what would happen if the CLG's HLC wished to provide comment and the owner and or chief elected official submitted such a waiver? So in this particular provision, it's specifically referencing the Code of Federal Regulations, Chapter 36, Section 60.6F. And while we tried not to repeat the federal rules, we did bring in pieces of it where it made sense. We were trying to not create a document that would be consistently referencing out of itself. And the federal rule is actually pretty explicit here. So it says that the owner and the chief elected official both must submit a waiver. So for instance, to waive the comment period for the local government, I would need a letter from both the owner or owners, how many ever owners there are, every single one of them, or a joint letter with all of them signing, plus the chief elected official. If I got one or the other or one owner held out, I would not expedite the comment process as part of the National Register process. That's pretty explicit. There is no rule for the Local Landmarks Commission in waiving that comment period. There's nothing to prohibit them necessarily from commenting, and I would leave that up to your local city or county attorney to kind of flesh out how that works. If I got a letter, I'd include it in the public record and it would continue to move up through the review process. But how that would practically work or be allowed by within a city or a county, that's a local issue to be sorted there. But for the comment period to be waived, I would absolutely have to have a copy from both the chief elected official, again, that's the mayor or county commissioner operating on behalf of the will of the elected body, and the owners in order to waive the comment period. So those are the 4 questions I got from City of Salem, and hopefully that answers some questions other folks had as well. I can take any other questions at this time.
In the chat feature, we had a couple of questions from Sandra Shotwell.
Okay.
So I will read them and then have you
Perfect.
answer, if that works.
Yes, that works. Thank you.
The tax rolls are proposed as the list of owners. They are often out of date and have been known often to add owners rather than replace old ones when a sale occurs. This inflates the number of apparent owners and the bar for 50% plus 1 objections. How can this issue be addressed fairly?
So yes, you're right. The tax records are often lagging. It is still, without doing a property by property title search, the best route to, or the most consistent and way to get a property owner list across the entire state. Generally, for most National Register nominations, they do not get anywhere close to a 50-50 split. My experience is either that we have a handful of objections or we have an overwhelming number of objections. How we deal with this is through, if it does get close, or if there are irregularities or other things, we have our section 13 in the rule that allows the State Historic Preservation Office to go through a process that of verifying both the owner list and owners and walking through that. It's not required upfront simply because I'll give you a recent example. The Redmond Historic District had a grand total of 2 objections to the entire historic district. And so not wanting to create an additional process or issues where it's not needed, it was decided that to create the owner list from the tax rolls. And generally the number of errors, unless it's very fine, is such that it would not throw it either way in our experience. So that's why we made the decision we did. I would encourage anyone to comment on that, whether they think that reasoning is sound or the provisions are sufficient.
Her next question, Sandra's next question is, what will the process for aging applications submitted before the new rules take effect? How old must they be before requiring resubmission?
So as written, the rule says that anything that is in process can go ahead and continue. So anything that's currently in our office and has not been withdrawn is considered in process and is not subject to that 2-year restart provision that I mentioned earlier in my presentation. However, there is a reasonable documentation standard the National Park Service holds nominations to. And so what we would generally do with nominations that have been hanging around a little while is we look at we will look at the documentation and make sure that it's reasonably current. Staff will often do a spot check in the field and photos and other kinds of things. National Park Service is very cognizant that any documentation is really a snapshot in time and uses a reasonably up-to-date standard. And because, especially if we're looking at historic districts, they do accept there will be a certain amount of change. And staff generally takes responsibility for making sure that those are up to date, although it would be a conversation with the proponent as well, whether that's an individual property, historic district, to make sure we're meeting that reasonable standard set by the Park Service that it's up to date. But anything that's currently in process will continue to be in process and will not be subject to that 2-year reset currently in the draft rule.
Okay. Again from Sandra, there are criteria used to demonstrate someone is an owner. Given the inaccuracy of tax rolls, what is the process for documenting that someone is not an owner, even if on the tax rolls? For Eastmoreland, there are 100 tax roll listings for Multnomah County that were not accurate. Most included old owners that had moved away and were not available. Sorry, I've lost. Went to submit objections and should not have been included in the owner list. What can be done about this? While the tax rolls may be the best system, it is unwieldy for a district with a large number of properties.
Yeah, certainly. That's a limitation of this particular tool. It can be a little bit unwieldy, but handling it is the responsibility of SHPO staff. If you look at sections both 12 and 13, there's a sharp definition of owner, but also as the documentation that may be required if we get to a situation where the accuracy really becomes important, where it could go either way. There's a process for which folks can ask us to look into things, including our own staff can ask to look into it, and there is a provision to us to be able to request additional evidence. It also allows us to look at any publicly available records and then to amend the list based on our findings. The rule basically gives this State Historic Preservation Office those authorities to go ahead and ask for that documentation, but doesn't get into, would allow staff procedures to outline more specifically how that happens. Under the old rule, the State Historic Preservation Office did not have the authority to look at more than maybe just publicly accessible documents, and not being able to really have someone demonstrate that they met the definition of owner. Again, what we would be looking for is if you had a district that came very close to that 50, simple majority of objections, we would be looking we would be trolling through the owner list and a lot more definition. A lot of this though is going to be driven by people bringing issues up to us if we don't see them. So and that's what section 13 is about, is under what circumstances we would go into a closer look. And so I'd encourage everyone to read both sections 12 and 13 of the staff procedures closely.
Great. So our next question comes from Sarah Robertson, and she has two questions.
Mm-hmm.
The first, 736-050-0240-8C, notes that the committee may participate in the review of appeals to the NPS of National Register nomination forms rejected by the SHPO.
Mm-hmm.
What governs when the committee would participate in the review of an appeal?
So if our State Historic Preservation Office, so basically it's if the applicant or the proponent requests it, or if the National Park Service orders it. So any decision of the State Historic Preservation Office is appealable. So for instance, the nomination's going through, we get it, it comes through the application process, and we say, well, we don't believe this property is eligible for listing in the National Register. We're not going to schedule it. The proponent could simply say, well, I really do want it to be seen. They could appeal directly to the National Park Service, or they could ask our office to submit it to the State Advisory Committee on Historic Preservation anyway. Both are viable alternatives. If we should refuse to submit it to the State Advisory Committee on Historic Preservation, the appeal would go to the National Park Service, and the National Park Service would decide if the SACHP, that review board, would see it again. If it went to if it passed by the State Advisory Committee on Historic Preservation and the SHPO refused to send it to the National Park Service, you would appeal to the National Park Service, and then it would be, if the Park Service wanted it sent ahead, then it would be sent ahead at that point. Although they could, in theory, ask us to send it back through the review board, but that would be kind of case by case basis. So at any point during the process, the SHPO, the State Historic Preservation Office, can halt a nomination, but the proponent can go ahead and request review at that point. But again, the National Park Service, and we've never done this, but if we were to really dig in our heels, they're the ultimate appeal body would either send it back for review by the State Advisory Committee, or just back to our office for another recommendation back up to them. I hope that answers the question, Sarah. If it doesn't, go ahead and ask me a clarifier there.
And you can raise your hand and I can make it so you can talk, so you don't have to type all of this. And once we get through the questions that are typed, we will ask for anybody who wants to just speak their question. The next question, let me make sure that's not Sarah asking. I gotta find who raised there. Oh, Sarah. So Sarah, you can hit unmute and.
Thank you. Can you hear me?
Yes.
Okay. Yeah, so follow-up question. I think, so I'm a planner for Oregon State University, and I think our staff were thinking kind of in some of our questions we've had about some of these revisions, we're
Mhm.
thinking about a situation in which there might be a substantive revision to our historic district on campus,
Mhm.
and potentially some disagreement about revisions,
Mhm.
either locally or objections to that by our local landmarks commission mayor.
Mhm.
And as I understand it, a state entity can provide comment to objections, but couldn't actually, what kind of recourse do they have to kind of disagree with a local landmarks commission if they blocked a revision to a nomination or district boundary change or revision to our district?
So I'm going to caveat this with interesting question, never considered it before. So let me make sure I have the question right. So you're looking at the university sponsors a revision to a nomination, and then it's blocked by the local government through the CLG, through the certified local government. They turn in their letter of objection from the chief elected official and landmarks commission, effectively ending the nomination process. Is that your situation?
That's one of them. The other hypothetical is, to potentially block development on campus. Someone nominates or expands the boundary of our historic district,
Okay.
to prevent potentially, development on campus that may or may not be controversial.
Okay.
What kind of, then how do those disagreements get resolved?
Sure. Okay. So those are two different situations. So so let's saying that the university sponsors a change to the nomination and the local CLG blocks it. My reading of the CFRs, but I would have Code of Federal Regulations, but I would have to go back and touch base with the National Park Service, is that anybody means anybody, and so the university could object to the objection and thus free it up to continue through the process. So that would be my understanding of that yes, the CLG could object, but the university would say, we object to your objection, and the substantive consequence would be that you would miss the hearing you were scheduled for under this rule and be scheduled for the next one. Now, if you made a bunch of what would be defined in the rules a substantive revision, that local government would get another opportunity to object and then another opportunity to delay you another 3 months. But that would be the substantive piece of it. As far as expanding the boundary, anyone can choose to nominate something to the National Register, and the way that the federal rule is written right now, subdivisions of government cannot object. So let's say the local community decide to try and expand your National Register Historic District over the opposition of the community. They certainly could do that, nominate it anyway. Now, whether it's successful, that's a different story. The university, of course, would be invited to comment and say, we don't think it's appropriate for any number of reasons under the National Register criteria. It's not historically associated with the context. It's not temporarily associated. There's a break in historic appearance or integrity over this period. You can make all those different arguments, and those would be seriously considered by the State Advisory Committee and my office as well. But you wouldn't be able to kind of halt the process. So does that answer your question there?
Yeah, it does. Thank
Okay.
you. Yeah, that was our understanding. So thank you.
No problem.
And Sarah, did that answer all of your questions, or do you still have other questions?
Let's see. No, that answered all of my questions for now. Thank you.
Okay, great. Thank you. So we're going to move on. We had a question from Rob Zoller. I have questions on determining the number of owners. Does a married couple who jointly own a house count as 2 owners? If their children are listed as owners, do they also count as owners?
Yes, in that situation, every single person who has title on the property, fee simple defeasible title, is an owner. So for instance, in my example, my wife and I are both on the title of the home I'm sitting in now. So both of us are owners. There's 2 owners for this property. If I also, if my cousin owned a stake in the property, he also, he would also have a stake in it. If I happen to also have this property under a trust, that trust as a legal entity would also be an owner.
So he further goes, if a property is owned by a family trust where the trustees and settlers are a married couple, does the family trust count as one vote, or does each trustee and settler count as an individual vote? So a married couple gets 2 votes.
That starts to get an issue of trust law, and it depends on how you've set it up. So if the trust is a single legal entity, then the trust is a single vote, regardless of how many trustees it has. And this starts to get into these types of questions, start to get into we have already had some questions. If it gets very close to that 50 mark, where we would start to dig in and look at it and want to see those incorporation papers to make an accurate determination of how many owners we're actually looking at. As well, many of you know, there's a lot of different ways to legally set up these types of ownership arrangements under Oregon state law. So it's a little difficult to answer them in hypotheticals. And very honestly, I would involve an attorney in some of these conversations if I were looking into it, because it's not my expertise.
Great. Well, we have a couple more questions from somebody who's already asked questions. So I wanted to open it up for anybody who hasn't asked a question yet. If you have a question, and then we'll go back to the ones who've already asked. So is there, and I see Tom Brown has his hand up. So Tom, it looks like I can't do that. So I'm going to move you up here. So Tom, you can now talk.
Oh, thank you. I'd just like to follow up with Ian's last response. If your answer is so vague and confused, how can you know how many owners are in a district, especially one the size of Eastmoreland?
So we would start with the property owner list as described from the tax rolls, and follow procedures there, and then we would count the objections. So we are going to use the tax roll list as assuming that it is accurate, and that is stated in the rule, and then add or subtract owners based on the receipt of notarized objections or statements of ownership based on that. And that is well described in the state or in the federal rules as well. When we get down to determining trust, there's some provisions in the rules, specifically in section 12, that address those. And when we get down to the finer points where we might have to do what's called a closer look or an investigation, section 13 describes those. So I'm pretty, yes?
You realize when the tax rolls are created that someone gets documents from a title company, a deed, and then someone types it into the system.
Yes.
The people typing it into the systems are not lawyers, so they make mistakes. And I mean, you're just admitting that you don't know who owns property.
Well, they certainly do make mistakes, Tom, and that happens in any kind of large district. But in this particular case, the standard will be, and like I pointed out, in the Redmond Historic District, or in districts like, for instance, the Coos Bay TCP, where there was overwhelming objections, that kind of detail becomes a moot point, and it's often, doesn't provide any additional clarity of process, because the nomination has either overwhelmingly been supported by the public or has overwhelmingly been defeated by those owners. Section 13 lays out a process that allows our office to, in good detail, identify those issues and sharpen that owner list, and sharply define owners when we need to. When it does, for instance, in the Eastmoreland situation, where that is relevant and something that we have done in the past. And so,
have you done that with Eastmoreland yet?
We have not done that with Eastmoreland yet, simply because the rule did not allow us to force property owners to provide documentation as to their ownership claims. We did it within the extent that we were able to, under the existing rule and process.
Well, Are you going to do it now with Eastmoreland, or are you just going to let it slide?
Well, we have a draft rule at this time, and so I can't speak to what we are or are not going to do. I can tell you what was done in the past under existing federal and state laws and rules, but what will happen in the future will very much depend on what ends up in this rule.
So it sounds like, Tom, you have some concerns about how the owners are determined. So that would be what we would encourage you to submit comments on.
Well, right. I mean, we've been commenting on that for 4 years.
But comment
okay.
through the rule process.
We have. I'm not. Yeah, that's fine. I just find it interesting that you're proving our point at a, right on Zoom, that all these property tax records need to be examined more closely than SHPO has been doing it, especially for Eastmoreland. And I'd like to also remind you that I believe Christy Curran said at a meeting that if we were even close to getting 50%, that the process would be halted. And I'd also like to make a statement that the Portland Landmarks Commission on February 16th, 2017, said that the Eastmoreland nomination should be held up and not be forwarded yet.
Well, I can have, if I can turn that into a question. The question would be, would the City of Portland Landmarks Commission have the authority to halt the nomination? Yes, they could have, should they so have chose, if they had submitted an objection with their chief elected official. But that particular comment does not have any larger bearing on the process because they did not. And that is an opinion, and the timelines and process and gates and requirements are set by the federal rules. So they, at no point did the City of Portland ever submit a formal objection by the Landmarks Commission and the chief elected official, and that's why that process went forward. They still have that they would have had that option, but that option has far been passed. So that's unfortunately at this time not relevant. As far as the accuracy of the owner list, if I may turn that into a question of when that is determined, that will, the Eastmoreland district, should it go forward, it will be handled accordance into whatever this particular rule is. And that will involve probably looking, as currently written, looking again at the ownership list and also the objections. And so I would encourage everyone who has a specific interest in that specifically to look at section 13. Which will be particularly relevant. And again, that's a big part of this rule, is the revisions of owner and how the list is determined and those types of things. And so any comments there would be very, very welcome, because we're trying to solve a lot of these problems that you're currently pointing out. So if there's any...
So on section 13, staff procedures, we can comment on that?
Absolutely. We were inviting comment on all of those pieces, please.
Okay.
Great. So let's move to see if there are additional questions. If you want to raise your hand if you have an additional question, or you can type it in either the question and answer on the top or the chat feature.
I see a final question by Sandra Shotwell. Did you want me to answer that now?
Yeah, she has a couple. I was just gonna wait
okay,
because you had answered a few of those.
Okay.
But if there are, she had a couple of questions, it looked like, that we didn't get to. So her question, we'll go to Sandra's question, and then if somebody else has a question. Sandra's question is, what role does historic racist behavior impact a designation? If a neighborhood had covenants that did not allow ownership by certain races and redlining occurred, does that play any role in consideration of the historic nature of a neighborhood built in part upon a history of racism? What is the status of changes being considered in the program at the National Park Service level? So 2 questions.
So I guess the question I have for Sandra is, I need to clarify to make sure I don't go off the rails and answer the question I think she's asking versus what she's asking. So there's And so if you could take her off mute so she
Yep.
could speak. Okay.
You can
So-
unmute, Sandra, and then you can.
Okay. So Sandra, thanks for joining me. I have a question for you. So, oh, I'll wait for the sound to be done.
I'm sorry, someone is calling on another line in the background. I have to wait.
Of course
Okay.
they are. Right when you.
Right,
unmute.
exactly when you unmuted me.
Yeah, of course. That's when it happens. So Sandra, are you asking about eligibility for listing in the National Register? Like, could you list a district because of its history of racist history? Or are you asking how does it affect the potential process, whether it could or could not be listed?
Well, let's say a property met the criteria for a historic district, but in part based on the fact that historically it was there were covenants that prevented certain races from entering. They were, and later economics, redlining was used so that only wealthy people of a certain skin tone could live in a neighborhood. And that was in part one of the reasons that a neighborhood remains elegant and very white.
Yeah.
Does that play any role in the designation of a neighborhood under the National Park Service district rules?
Sure. So, I guess I'll answer that from two different perspectives. So you could certainly list so first of all, the National Register is not the National Register of beautiful places or history we like or think is pleasant. It is the National Register of Historic Places, and it recognizes, honestly, some really ugly moments in our national history, which are not important, but not necessarily something to be proud of. The racist nature of a neighborhood certainly could be the basis for listing a property, historic district in the National Register. It would still be subject to all the same criteria. You'd have to demonstrate that it particularly demonstrates those physical qualities that would demonstrate that. And you mentioned like the elegant houses, but there might be other physical things that would demonstrate that. And you could say this neighborhood is eligible because it is a product of redlining and segregation and all these other housing policies that allowed this particular place to be created in this way. And so that is certainly something that you could argue. I have not seen that argument come through yet. What I've generally seen is the reverse argument, which is because of redlining or exclusionary policies, this other community formed or this other place formed. But from my knowledge working in the National Register program, you could make that other argument as well. Whether it'd be successful, I'd have to see it run through the process and see whether it was successful. From a process standpoint, because a neighborhood has a racist history, it would not preclude them from going through the process. The National Register process is open to anyone who would like to nominate their neighborhood. They just need to make a case for why it is historically significant. I like to point out that there's lots and lots of old neighborhoods and there's lots and lots of old properties. That doesn't necessarily make it all eligible for listing the National Register. I would describe the National Register as a little bit of a greatest hits. In many ways, it's designed to really kind of point out those things that signal those larger trends. So if you have 5 to 7 similar properties, let's say all designed by the same architect, the Park Service will always ask the question, well, what's the best of their work that best exemplifies what they do? And so we're not going to list 10 of their homes that they designed. We want to know what really captures their aesthetic. So you might list 1 or 2. Does that answer your question, Sandra? Is that what you were asking?
Yes, thank you. It does. Okay. And I'm also interested to know, I had understood that at the National Park Service level, changes to the program were being contemplated. And I wonder how those changes, what the process is or the timing, if you're aware of it, and how that impacts the Oregon administrative rule process for its work with the National Park Service program.
Sure. So, and just a clarification, are you talking about the changes to the National Park Service rules, the Code of Federal Regulations?
They manage the historic district program that we're discussing here, the Oregon level of it. And okay. I understood that there were some changes happening at the national, at the federal, the law level of federal law. So the Code of Federal Regulations.
Okay. Yeah. All right. That's what you're asking. I just wanted to make sure, because again, I didn't want to take this off in a a strange place.
Thank you.
So yes, this National Park Service is considering revising the Code of Federal Regulations. About mid last year, summer last year, they put out a draft, and that was commented on, and they received a number of comments from across the country. There were some changes, a variety of different changes, one of which was to consider property ownership by area owned. So that would be part of the calculation, not only number of objections, but total amount of space owned. So if how many acres belong to the folks who object and how many acres belong to those who do not. There was a number of other changes as well. There has not been any direct communication from the Park Service to the SHPOs since they closed the comment period last year. They did say that they planned on adopting the rules in October. That's real close here, and I have heard nothing, and neither has anyone else. We've been checking in with them. It's unclear whether what they may or may not do. Should they adopt new rules, what we would be doing is we would be basically, hopefully it would be before we would be adopting our rules, and we could make the changes to reflect the federal law, whatever that may be. If they did it afterwards, we just go through another rulemaking procedure where we would just adopt the federal rules, which is a little simpler than what we're doing now, where we would say, federal law changed, this is what we're supposed to do, we need to make these edits, and those edits would be limited to, because we just went through this big process, the edits would be limited to just coming into line with whatever the federal rule was. But unfortunately, I can't tell you what the National Park Service has been up to because they've been incredibly non-communicative.
Let me take the opportunity, if I'm still not muted, to just thank both of you for taking our questions and being so responsive and clear. I appreciate it very much.
No problem. Thank you.
Sorry, I was still on mute. Did that answer all of your questions, Sandra?
Thank you. Yes.
Okay, great. Is there anyone else that has a question? Well, Ian, it looks like that is it for questions. So that ends the informational portion of our meeting. So if you were here just to get information, we appreciate your attendance and thank you very much. Again, comments are open currently through August 31st at 5 p.m. We would love to have you or your local government comment. It can be done online at our website in writing or via email. And we will gather all of those comments and share them with the Parks Commission for a final decision. We are now going to move into the public hearing portion of our meeting. And this is an opportunity for anybody that wishes to provide public comment orally to do so. There will be no decisions made here. Each person will have an opportunity to speak for up to 3 minutes. And we don't have people registered, so I'll just ask anybody that wishes to provide comments to raise their hand. And the meeting is being recorded and will be posted on our website. And I'm going to read a statement opening the public comment here portion of the hearing, and then we'll move to public comments. So this hearing is now in session. It is being recorded to maintain the permanent record. My name is Katie Gothier. I'm the hearings officer. Today is August 18th and the time is 11:01 a.m. The purpose of the hearing is to provide an opportunity for public comment on the proposed rule change to OAR 736-050-0220 to 736-050-0270 by the Oregon Parks and Recreation Department regarding the National Register program. The agency invites comments about whether other options should be considered for achieving the rule's goals while reducing the negative impact on business. In addition to presenting oral comments at this hearing, anyone may submit written comments until 5 p.m. on August 31st, which is the close of the public comment period. Comments received after the close of the public comment period will not be reviewed or considered by the agency unless the agency decides to extend the public comment period for everyone. Send comments to the public comment mailbox or the State Parks office. The addresses are posted on the PowerPoint screen. OPRD will not respond to questions during the hearing. After the close of the public comment period, staff will prepare a report for the agency, which will be available from the agency upon request and will be presented to the Parks Commission as they consider adoption of the rules. If you have questions as part of your testimony, I would appreciate if you could state those as questions as concerns for the record. Please do not ask questions of those who are making formal comments. To provide better context for comments, I may ask follow-up questions. To respect each speaker, anyone not presenting has been muted. I ask that you limit your comments to 3 minutes. And again, you may submit comments up to the close of the public comment period. The chat feature can be used for asking process questions. Thank you for coming and providing us comments. The hearing, oh, that's the end, sorry. So is there anyone that wishes to provide formal comments this morning? If you want to raise your hand, then I see we have one, and I gotta get my little mouse up to that person. So Tom, you are, so if you unmute, you have to unmute. Let's see, I can't. If you hit, there you go.
Thank you. Thanks. After reading the testimony, I would like to clear up some mischaracterizations that have been entered as testimony. The first one is the idea that Mary Kyle McCurdy is working as a chief strategist for some organization or some group. That is just simply not true. And I think it's very, very hurtful and destructive to her reputation in the neighborhood. And I think it should stop. And I hope you guys know that she's a very great person. I know you guys do. And the other one is none of us trying to defeat the historic district are residential developers. And we've been characterized as wanting to defeat this historic district because we want to profit from it. And this is just simply not true and a fabrication. And again, it's hurting people's reputations and relationships in the neighborhood when people submit testimony like that. Honestly, a lot of the testimony I've read from the Eastmoreland residents that want the historic district it's just attacks. It's not true testimony. So I know that you're looking at the real testimony, but you just have to know that this is just wrecking Eastmoreland. It's tearing it apart, and it hasn't stopped. Again, thanks, Ian. You've done a great job answering everybody's questions. I can't believe you have all that in the top of your head. It's pretty impressive.
And thank you. I appreciate that. And thank you for your testimony.
Yeah, thank you.
Thank you. Is there anyone else that would like to provide testimony? Okay, well, we would encourage you to provide it online or in writing via email or snail mail. But we thank you very much for taking the time to attend the hearing today, and look forward to working with you all in the future. Thank you very much.
And Katie, if I may, we really do encourage folks to turn in comments and on the rule. Whilst we have worked very diligently with our Rule Advisory Committee and other partners to try and work through all this and think about it, most certainly the more eyes and comments we get, the better and more effective the rule would be. So please do not think, well, I don't have anything to say, or I don't really have anything to contribute. Really, we will be looking at every single comment and considering it because we, as an office, have an interest in making sure this program works well. So please do submit comments.
Great. Thank you all and have a good afternoon.